This podcast is sponsored by Murgatroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgatroyd.com/podcasts.
Hello and welcome to the 5th season of Murgatroyd's Innovation Talks podcasts. We're delighted you have joined us. If you have any questions, you can email us at innovation.talks@murgatroyd.com or contact us via Twitter @Murgatroyd. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Well, hello everybody. My name's Suèr and I work in the Aberdeen office of Murgatroyd as a European patent attorney and design attorney. I am delighted to be here today with my colleagues Wendy Crosby and Eleanor Coates. Wendy Crosby is head of designs and she's also a European patent attorney, also working out of the Aberdeen office. Eleanor works from the Glasgow office and is a trademark attorney there. We're here to talk to you today on the effects of Brexit on your IP, and we hope to cover patents, designs, and the trademarks side of the effect of Brexit. On the patent sphere, it's very much business as usual. Now, this is because the European Patent Office is governed by the European Patent Convention rather than anything to do with the EU as such. It is a separate institution. And as such, Brexit actually is going to have very little effect on how we deal with European patents day to day. UK individuals and businesses following the end of the transition period at the beginning of next year will continue to be able to apply for European patents through the European Patent Office, and existing patents, European patents, will be unaffected by Brexit. All our attorneys who are qualified European patent attorneys similarly will be able to carry on representing their clients within the European patent system. But if I now hand over to Eleanor, she can brief you a little bit on the situation in relation to trademarks, which is much more complicated.
So what you're saying, Stephen, is that you don't have a great deal of difference coming up with Brexit?
Fortunately, I don't know.
Well, yes, for trademarks, there is a lot more going to be changing. I mean, a number of companies will have not just UK trademark registrations, but will have protected their trademarks and brand names and logos as EU trademarks covering all 28 member states, which at current, of course, includes the UK. Now, if you do have EU trademark registrations, they will not cover the UK after the end of the transition period, which is on the 31st of December 2020. Going forward, you will still retain, however, your EU trademark registration. It will simply just cover the 27 member states. And it's also worth pointing out that if you have national UK trademark registrations, they're not going to be impacted either. If, however, you only filed for an EU trademark registration in the first place and didn't have a corresponding home UK registration, you're not going to lose your right because you are going to get a comparable UK trademark registration issued automatically and free from the UK IPO, because the government has put that into the actual withdrawal agreement that it signed with the EU. The statutory instruments as well, which bring that into force, have actually all gone through Parliament. Everything was prepared for the 31st of March this year. So the legislation is in place, assuming, of course, we have no tampering, but I can't imagine that tampering with IP is going to be an issue. So you will get given automatically and free. And it's on the 31st of December, you will get your UK comparable trademark registration. And Wendy, the position there is quite similar for designs, isn't it?
It absolutely is, Eleanor. It's the same situation in respect of designs as trademarks. If your EU design is registered at the end of the transition period, then the UK IPO will automatically create, I think they're calling it a cloned registration, as soon as the UK leaves the EU. So as of the 1st of January 2021, instead of having a registered design covering 28 countries in Europe, you'll have that EU registration that covers 27 countries and a standalone UK registration just covering the UK. So in effect, clients aren't going to lose any rights in terms of what their design previously covered. The difference is it's going to be in 2 registrations rather than only in 1. So exactly the same there for designs as for trademarks.
But unfortunately, it's not quite the same for the applications, is it? both in trademarks and designs, we have the issue if you have an application which is pending, and there are divergences in designs and trademarks, which we're just going to go through. But for an EU trademark application filed at present, it's not going to secure registration before the 31st of December. An EU trademark has to go through a 3-month opposition period. And given we're now in September, an examination would take 2 to 3 weeks, possibly a month, maybe even 2, 3 if you have objections, you're not going to get that registration through. So if you're filing for an EU trademark application now, by the 31st of December, it's still going to be an application. If that occurs, you're not going to necessarily lose the UK rights, because obviously part of your official fees for an EU trademark registration at present are actually go to the UK government. So they're going to honour that, but you are still going to have to apply for your comparable trademark application, and you will have to pay the UK application fee to do so. You get a 9-month period after the 31st of December to request that comparable UK registration. And Wendy, it's the same for designs there, isn't it?
Certainly the same situation is going to occur, Eleanor, in terms of if your EU registered design application is still pending rather than registered at the 31st of December, then you will have to apply for your UK application rather than having a cloned registration created automatically. And one major difference that we have in relation to designs and trademarks is in relation to the prosecution cycle of designs, where in Europe that's a very, very short time. So whilst, as you were saying, Eleanor, if you were to file an EU trademark application now, it's highly unlikely that's going to be registered by the end of December. It's very different with designs, because if we're filing registered design applications just now, they're likely to be registered within a matter of 2 to 3 weeks. So there's still a tremendous opportunity for people to file EU design applications now in order to get the registration completed before the end of the transition period. And the enormous benefit of that is, as we've just said, come the end of the transition period, the UK IPO will automatically create your cloned registrations based on what's already registered in Europe. So I suspect that there's going to be a very large increase in the number of European design applications being filed between now and probably, I would say, the beginning of December. So one thing I would say to people that's very important, if you're interested in securing EU design registration, there's a tremendous benefit from filing sooner rather than later, because it avoids having to take action independently once the UK leaves the EU, and it obviously also avoids the additional fees that will be required. So a difference in timing, but yes, we do have exactly the same situation as between design registrations and applications.
Does that mean that presumably you've been filing UK rights already a lot for marks, which ordinarily you would have just gone ahead for community trademarks?
Yes, I mean, companies and clients have been quite risk averse because they've known this has been coming. So many have taken the step, certainly since July, because EU trademark application, it will take at least 4 to 5 months to secure registration. And then you've still got the risk of being opposed. So you need probably a full 6 months to be sure that you would get the registration through before the 31st of December. Of course, if you file it fast track and you have a good specification and you're using the approved terms of the EU IPO, it is possible to get that registration through in a very quick time, possibly even 3.5 to 4 months. So, you're really talking at the last few days that potentially you could manage to secure an EU registration, but you're going to be cutting it really fine. And the EU Trademarks Office, I don't think will necessarily rush to issue out the registrations over the Christmas period. And I think that's what you've really got to take into account. There's going to be a slowdown from 23rd of December. So if you've not got your registration through before then, you may not get it through before the crucial 31st of December deadline. What I was just going to come back to say about designs, Wendy, is that it's worth mentioning to people that, designs don't just cover objects and 3D objects and everything. They also cover logos, logos, packaging, ornamentation. So even as a trademark, clients may think that they don't have any designs that are worth protecting, so they can't make use of the design system that you're mentioning there, and the fact that this, you can file your EU and get the UK still for designs. But actually, if they have new logos or new packaging that they're wanting to protect for products launching, in the December Christmas market or into the new year, they could still get their design registration through for those logos.
I think that's certainly a really important point, Eleanor, and also the fact that design filings at the European Designs Registry, we can file multiple design applications that give people the option to reduce the official fees being paid per design. So particularly if you're looking at packaging, for example, and you have the ornamentation that would be on the outside of the box, the branding, if you like, that sets your goods apart from others. There's lots of different opportunities that we can look at to protecting different designs. We can perhaps only protect part of the package in one design application and a different part in another, which can give companies a lot of different opportunities to, if you like, effectively build walls around their main branding. But the opportunity of getting that through as a registered design with the additional protection that comes from that before the end of the transition period for the types of things you were mentioning, the external bottle shape, for example, if it's a whiskey bottle, or the particular branding that appears on the box. I've even seen design applications for crisp packets that use different colour blocks on different parts of the package. All of these things allow you to take action against competitors who are using the branding that's very important to your company in a very similar way and trying to muscle in on your protection. So getting those filed as design applications now gives a tremendous advantage to these clients, and it's something I think we shouldn't overlook.
Well, particularly if they're going to get their UK comparable or cloned registration for that through and get both for the one cost of filing your EU design. It certainly is quite a strong advantage there.
I think something also that we're seeing a big expansion in terms of the design side of things, partly, of course, because they're not limited by product as such. It's not like a trademark where you're limited to a specification of goods, but in relation to graphical user interfaces, we're seeing a lot of those being filed for designs at the moment. So basically screens of tablets or phones, those sort of things, and how they go through a series of movements or a series of iterations.
Just really useful for companies who have products coming out, as I say, for the autumn-winter market. You need to get your registration in place, because one of the issues that is going to come up with Brexit, as I say, is the fact that you're going to have to file for both an EU trademark registration and design registration after the 31st of December. And it's trying to sort of think about what protection can you get that perhaps might take advantage before Brexit actually occurs, because, as I say, next year we will be looking at having to file both the national UK registration and your EU design or trademark application.
I think also, Eleanor, there's an aspect there, both in trademarks, but again, particularly in designs, because in comparison to traditionally patents, which tend to have a very long prosecution cycle with fees paid at lots of different times, and you're perhaps 2 or 3 years down the line and still unsure if you've got something that is finally granted. I think with both trademarks and also designs, once they're registered, you know when the next steps are going to be in terms of renewals. So for example, with designs, once they're registered, nothing's going to happen for the next 5 years, and you're going to have an opportunity in 5 years' time to decide whether or not to renew each of your designs. And if you're avoiding the step of having to pay additional fees in relation to protecting the UK separately, because that's already covered in your EU rights, again, that gives people an ability to look forward, particularly just now when we have the COVID-19 situation and all the uncertainties that come with that, not having to use part of your IP budget to protect rights that mirror rights you already have. The fact that's all going to come automatically, I think is a big advantage. So where we have 5-year renewal periods in designs, I think I'm right, Eleanor, in saying it would be 10-year periods in trademarks.
That's right. Generally, there's 10 years in trademarks. There's two ways of looking at it. It depends for clients what they're wanting to achieve, really, for Brexit. Because the one is that potentially you're looking to sort of try and get your rights through so that you get both an EU and a UK registration. The other side, of course, is whether you want actually to have a registration before launch. And that's important too. I mean, for example, at the present, if a client is thinking about launching a product in January, or they're thinking about launching one for the December market, then we would probably say, even at this stage, you want to be thinking for trademarks about filing a separate UK trademark to make sure, because the UK trademark procedure is very quick and you can get registration within 3 months. So you could have your UK registration through so that you can actually launch the product with a registered trademark after the end of the transition period. Whereas for your EU trademark application, you're going to be waiting that little bit longer.
It's funny that you say that, because the prosecution cycle on designs is slightly longer from the UK side than it is from the EU side, because there's the examination that's carried out in the UK, whilst it's still not a full substantive examination that we might see in the US or China. It's still more than it would normally be from the EU side. So I would expect probably an extra month or two perhaps of delay, and possibly more objections being raised on the UK side during prosecution than I would do on the European side. And that's something, again, that ties in. If we are in a situation of having designs that have been filed but are not yet registered at the end of the transition period, so we're having to refile in the UK, that new UK application will be treated as a national UK case and examined as a national UK case. That's one thing I will be writing to all of our clients who have taken the step of filing design applications recently, but deferring the publication of those designs for a period of time, because anything that is in the deferred publication cycle will be treated as a pending application at the end of the transition period rather than a registration. So I know that we have clients who have been holding back some designs, waiting for product launches, but there's a decision now to be made whether it's better to release those designs for registration before the end of the transition period to get the cloned UK registration, or if the product launch hasn't started yet and they want to keep the benefit of the design being a secret, that's something that they're going to have to look at refiling in the UK, if the UK is an important market that they're looking for to have design protection in.
I was just wondering some aspects that affect all of us in terms of what we're trying to do for our clients right now, rather than specifically just talking about registration processes, is looking at other aspects which they need to consider as we approach this deadline. And I was thinking in advance of this, partly to do with things like exhaustion of rights and contracts and terms in contracts. And I know we don't have all that much time to discuss all these issues, but I'm sure that we'll have conversations with our clients about what they should be looking at in terms of any contracts that they may have with clients where the term EU crops up all over the place and how this situation might affect them. So I don't know if either of you would like to comment on your own experiences there.
Certainly drafting contracts going forward, even from at this point in time, and I say this point in time, but also in the previous year since we've been aware of this Brexit transition deadline approaching, for clarity, it's better to set out exactly what countries you're saying are covered by the term EU. So if you have contracts coming up, it's better to put in the EU comprising of all 28 member states, including the UK, whether the UK leaves in future. And actually be far clearer on the issue of territory than you would otherwise be. Wendy, how about you? Do you have any points there?
I think that would probably be the same from a design perspective. And I think I'm right also in suggesting licenses, again, should be checked just to make sure the terms in the license are clear and that there's no confusion or misunderstanding going forward in relation to what is or is not covered in different terms. I think we've all been advising clients for some time to look at these issues and make sure everything is all up to date on them. One thing that occurred to me, Eleanor, just in relation to trademarks as opposed to designs, what would the situation be with an EU trademark that's going through opposition at the moment? Is there anything that we have to think about there in terms of Brexit?
There is, unfortunately, quite a lot to think about there. If you have an EU application which is going through opposition, if the opposition is based upon a UK right, which would have been a valid basis for opposition, the opposition will fall away if that was the only right the opposition was based upon. So if you had an EU trademark application that perhaps was filed 3 years ago and is still in the middle of an opposition procedure, and the basis of that opposition was solely based on either a UK registered or unregistered trademark right, then that opposition will fall away after 31 December. The EU IPO will not be recognising the UK basis, which is going to be quite a big change, certainly going forward for clients and looking at what basis you're actually filing oppositions going forward. Try to make sure you've got a basis which is not just the UK. Certainly, we've been trying to do that over the past year. Is there a French national registration or a German registration? Is there another right, perhaps even a company name right in one of these countries that you can include as the ground for opposition? And also the same will happen with cancellation actions going forward as well. Exactly the same basis that if you've got a UK right forming the basis of the cancellation action, then after 31st December, that will fall away. It's unclear yet exactly what will happen with that, or how the EU IPO is going to manage it, whether they'll just simply write to us and tell us that the matter is concluded, or if there will be any other scope to take action. I think the matter will end up being just concluded, and if you want to then further challenge the EU registration, it would be open to you to file a cancellation on another right if you have one.
In terms of unregistered rights, actually, Wendy, I understand that there is provision for a new UK unregistered right for design rights to sort of mirror what was the European unregistered design right, because I understand they're slightly different, the UK and the European take on unregistered design rights.
Absolutely, Stephen. One of the major differences between EU and UK unregistered design rights is that in the UK, unregistered design rights don't cover surface decoration, whereas in the EU they do. Another difference would be that in the UK, we have a longer term that the right exists for. So normally a maximum of 10 years within a 15-year window, whereas in the EU, the rights are limited to 3 years. So there's a lot of differences and changes coming there. But similar to what we've been talking about with registrations, the UK IPO is going to ensure that nobody loses out at the outset. So any EU unregistered design rights that currently exist and whatever period they have left of their maximum 3-year term is going to be mirrored in an equivalent UK unregistered design right. But we are going to have to look going forward at some very specific issues with unregistered rights, because they often are based on where the first disclosure of a design has occurred. And previously, that would have been anywhere within the EU would have brought the rights into existence. But in future, there's going to be differences of looking at where the first disclosure was as to whether it's an EU right but not including the UK that's created, or if it's a UK right that's created, or indeed if there's any rights created at all. So again, it's going to be a much more complicated procedure, where we previously had both UK and EU design rights acting simultaneously. We're now potentially going to have a number of different rights going forward. We're going to have UK unregistered design rights, a continuing design right that was equivalent to the EU right that was in existence, and potentially a third right which is the equivalent of what you would have got had we still been in the EU, so covering surface decoration, etc. But that EU-wide right is no longer available. That's certainly a much more complex picture going forward than we've had up to now, unfortunately. I think also we mustn't forget the fact that in leaving the EU and when these independent standalone UK registrations are created, another unfortunate side of that is that rights owners are going to have to look at paying renewal fees on both an EU registration and also a UK registration going forward. So ensuring that your records are up to date in terms of the rights that you have and monitoring those deadlines will become slightly more complex. Hopefully we can, all of us, make that a lot easier for our own clients. But it is something that people are going to have to look at going forward.
It's worth mentioning there, Wendy, as well, that if you renew your EU your registration before the 31st of December, you've still got to renew the UK comparable. We are going to get a long grace period, though.
It's funny that you should say that, Eleanor, because I've already had 2 or 3 inquiries asking, can we anticipate the situation by paying the renewal fees in the EU early so that we avoid exactly that situation? And unfortunately, the answer is no, you can't. You can pay them early if you want to, but you don't avoid the need to also have to pay the standalone UK fees. So I think that was something very early on that people thought that there was a tremendous opportunity to make cost savings, and that door has been very, very quickly shut. I think in summary though, and you made some really important points at the beginning, Eleanor, in relation to clients looking to introduce products in the autumn and particularly in the run-up to Christmas. It's funny sitting here at the moment in September thinking Christmas sounds so long away. It really isn't. And there are things that people will have to be thinking about very quickly in order to take advantage of the opportunities that are there. But I think the message from all 3 of us is very much that we're on top of this. We know what's happening, whether it's patents, trademarks, designs. We can help people in relation to any of those and any Brexit questions. Murgatroyd has a Brexit hub on the Murgatroyd webpage, and I would recommend that anyone feed any questions or any queries to the 3 of us on that webpage, because that's just a useful way for us to gather everything together. But there's also a lot of very helpful information, I think, to people that we've already provided and put on there as a first place to stop to look for information.
So are there any last points, anyone? I would probably say, just on terms for clients, it is having a look at their portfolio going forward, seeing where there are duplications and considering what do they need to do with the portfolio. You can, if you do get awarded a comparable, right, allow it not to be in existence. It's always worthwhile, to be honest, to look at your portfolio. But I think in the next coming few months, it is particularly worthwhile to have a good look and see what is required, what is not required, and keep on top of the deadlines, which I know we will certainly be doing.
I think that's right, Eleanor, and particularly for our UK-based clients, having a home registration in their own country is probably going to be a very important thing, even though with the internet now being the way that it is. And for a company, it might be that your biggest market is China or Germany or France. It might not be the UK, but I'm sure that there will be a lot of companies looking to see whether the UK is a significant market for them. And again, I think you've hit the nail on the head. This is an opportunity to review your portfolio, something that you should be doing anyway, because it's always amazing what comes out of that. And it's helpful when you have an IP budget to be able to ensure that you're focusing that in the right areas rather than on less important matters. I guess that's the same in patents as well, Stephen, as it would be for the other rights.
Absolutely. I think this is a critical time, really. Patent side isn't really any different. We've got sort of 3 months-ish worth of time, which is an ideal time to do this. For auditing, it's always great to do an IP audit. I always recommend it.
It's been great catching up with both of you. I am really hopeful that at some point in the next few months, we could actually all be sitting around one table in one office. It will be really great to get back together again and hopefully share a coffee when we're discussing our issues with Brexit and why were we worried at all, because it's all so smooth and everything is all falling into place. I'm sure it will.
Well, it might be for IP at least. I'm not sure about everything else.
Well, so it's probably time to wrap up. So just a quick thank you very much to both Wendy and Eleanor for joining us on this call, and we'll see you all next time.
Bye now.
Thank you.
Cheerio.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgatroyd.com.